Hi, this is Kaushik Ranchod from the Ranchod Law Group, and I want to thank you for joining us on our Q&A on immigration, and specifically today we're going to talk about same-sex marriages in the recent Supreme Court ruling that made DOMA unconstitutional. And we're going to talk about how this applies to you if you live specifically in Northern California, San Francisco, Sacramento, and the San Jose Bay Area.
Thank you, Kaushik, for that great introduction. My first question is, do I need to be married to my same-sex partner, or is the relationship of long duration or cohabitation sufficient?
Excellent question. Yes, you must be married, just like any other type of marriage-based application for heterosexuals. The basis of the application is marriage. And so what that means for you is that even if you were living together, even if you were living together for, let's say, 2 or 3 years, that would not qualify. You would need to get married, and then you're eligible to apply, of course, if you have a real relationship.
What if I live in a state that does not allow same-sex marriage? Do I have to move?
No, you don't need to move, and since if you live in California, many of our clients now are eligible by getting married in California, and luckily California is one of the states that allows for same-sex marriages, and you can go ahead and apply regardless of whether you live in this state or not.
And where can I get married?
States that do allow for same-sex marriages are California, Connecticut, Delaware, Iowa, Maine, Maryland, Massachusetts, Minnesota, New Hampshire, New York, Rhode Island, Vermont, Washington, and Washington, D.C.
Okay. And after getting married, what is the first step to petitioning for my same-sex spouse?
So, in San Francisco and Sacramento, in the marriage-based green card application process, the first step is preparing all of the necessary forms, for instance, for the marriage-based green card. Some of those forms include the I-130, I-485, I-130, G-325, I-765, I-131 travel document, along with all of the supporting documents that go along with that application. And then at the time of the interview at the local district office, and there's 3 local district offices in Northern California, that's San Francisco, Sacramento, and San Jose, you would have the interview there, and at that time the officer will want you to collect all of the joint documents you have and bring those to the interview. Some of the joint documents you may have are a joint lease, joint bills, joint bank account statements. Any of those documents that you have, you'd bring to the interview.
Okay. So if I'm a U.S. citizen or lawful permanent resident in a same-sex marriage to a foreign national, can I now sponsor my spouse for a family-based immigrant visa?
You absolutely can. So just similar to filing a marriage-based green card application where your spouse lives in the United States. Alternatively, if they're living outside the United States and you're married, this process is known as an immigrant visa, where you'd file an I-130 petition. And when filing the I-130 petition, for those of you who live in California, you file that with the local California Service Center. Normally that process right now at the time of this video is taking anywhere from 4 to 7 months to get approved. Then it goes on to the National Visa Center. They'll ask for a host of other documents, including demonstration that you can actually support your spouse via the Form I-864, the last 3 years of tax returns, W-2s. Your spouse is going to need to provide their original birth certificate and a host of other documents. That's all screened out by the National Visa Center, and then it goes to the U.S. Embassy, where your spouse would have an interview there, and then they can enter the United States after demonstrating that they meet all the requirements.
So if I'm a U.S. citizen who is engaged to be married to a foreign national of the same sex, can I file a fiancee or fiancee petition for him or her?
Yes, you can also file a fiancee visa petition as well. And for those California residents, you apply at the California Service Center for the petition, and then it again goes to the specific U.S. Embassy.
If my spouse and I were married in a U.S. state or a foreign country that recognizes same-sex marriage, but we live in a state that does not, can I file an immigrant visa petition for my spouse?
You still can file for the immigrant visa petition. So, for instance, if you were living outside of California, such as a state like Georgia, you could still apply if you were married in California.
Do I have to wait until USCIS issues new regulations, guidance, or forms to apply for benefits based upon the Supreme Court decision in Windsor?
The fantastic news is no, you don't need to wait. You can apply right now. And in fact, we're preparing applications right now.
I know that the immigration laws are discretionary waivers of certain inadmissibility grounds under certain circumstances. For some of those waivers, the person has to be the spouse or other family member of a U.S. citizen or of a lawful permanent resident. In cases where the required family relationship depends on whether the individual or the individual's parents meet the definition of spouse, will same-sex marriage count for that purpose?
It will. So in this specific situation, and this is an excellent question, like where this occurs is, let's say your spouse entered the United States illegally, they entered only one time illegally, then they're eligible for an I-601A waiver or an I-601 waiver, and you can, as long as you have a bona fide marriage and you're married, you can also apply for the I-601 waiver. I want to thank you so much for joining us on our immigration session. This was a lot of fun discussing these issues with you, and look forward to discussing the latest immigration news with you in the future.